Good morning, Chris, and thank you for coming in today. Although we do know each other, I just need to officially remind you that under my role as a workplace relations advisor, I've been asked by you to give you some advice regarding a workplace conflict issue that you've been having. I've examined the case that you've brought to me and I see that there has indeed been workplace conflict. There appears to be two different issues presented within the situation that you have at work. The issue with Alex and the issue with your supervisor, Brian. Let's begin by having a look at your belief that you're being bullied. Bullying is a very serious issue in the workplace, and unfortunately it's not uncommon. In fact, researchers have found that nearly 50% of Australian workers have reported victimisation in the workplace, and another study, published in America, found that nearly 95% of workers will be exposed to some form of bullying in a 5-year period. Bullying in the workplace is a serious issue, and one that has been taken very seriously. The impacts of bullying has been well documented. Workplace bullying impacts on workers' physical and mental health and on the workers' general well-being. The first thing to consider is if Alex is indeed bullying you. The legal definition and the definition that is provided in the university's workplace bullying and intimidation policy is that bullying is the repeated, less favourable treatment of a person by another or others in the workplace, which may be considered unreasonable and inappropriate workplace practice. It includes behaviour that intimidates, offends, degrades or humiliates a worker. The policy goes further, giving examples of types of behaviours that may constitute bullying and intimidation. Amongst these examples are the following description of bullying behaviours: belittling opinions or constant criticism, yelling or screaming or offensive language, insults, and isolating workers from normal work interaction, training and development or career. So, given that whilst the first incident that you had with Alex was 3 months ago, and since then you feel that she's driven a wedge in the cooking team since that initial meeting, then you could say that her behaviour is less favourable and repeated. She has made belittling and humiliating comments, and because of her action, you have been excluded from team meetings and during lunchtimes. From your accounts, Alex is responsible for turning the other cooks against you, and you are feeling isolated because of her actions. Her behaviour could be classified as gang bullying or mobbing. The other person involved in this issue is Brian. As your supervisor, it appears that he is in breach of the workplace bullying and intimidation policy put in place by the university. The policy clearly states that managers and supervisors have a responsibility to proactively promote a workplace free from bullying and intimidation on incidents, to inform staff of the action that they can take if they feel they are being bullied or intimidated, to arrange or provide adequate and appropriate support, and to deal fairly with all persons involved in the allegations. Given that you did, in fact, raise your concerns with Brian and that he did not appear to address your informal complaint or take steps to speak to Alex, then he does seem to be in breach of the workplace bullying and intimidation policy. However, it must be noted that the policy does not provide advice to supervisors or managers about the processes needed to handle these complaints. This oversight in this policy is one that will need to be addressed, and I will be passing this information on to the policymakers at the university. I am also going to request that Brian and the other supervisors receive some refresher training on how to handle bullying and workplace harassment within the workplace. You have many options available to you, Chris, should you wish to act. You should consider each option carefully before you decide what action, if any, that you will take. Later in this presentation, I will address the pros and cons of each option so that you do have a complete understanding of what you'll face if you choose to act. There are 4 types of actions that you can take to address the issues that are currently facing you in the workplace. The first 3 of these options are addressed within the university's policy and procedures. You could make an informal communication or complaint. You could undertake mediation, or you could make a formal complaint. Additionally, you could appeal to an external system, such as the Fair Work Commission or the Occupational Health and Safety Act. I will explain each one of these processes further to you. The first option of the informal communication complaint process involves you having an informal conversation with Alex and Brian about the issues that you are facing. This informal chat could happen with a supervisor and/or a representative in the room to support you. You could seek advice from an experienced third party, or you could request your supervisor to speak to Alex and the other staff about their behaviour in the workplace. In addition, you could also undertake some conflict management training, and you could use that to address the issue with Alex yourself. The second option that you could take is the mediation process. Mediation is a controlled communication process that requires the cooperation of two parties in finding a resolution to conflict. Within the mediation session, the mediator follows a set formation and guides the sessions, of which there could be a number. The mediator focuses on exploring the issues, clarifying concerns, and allows both parties to express their points of view. The mediator then works to negotiate an agreed resolution to the issue and, ideally, a specific settlement agreement is created, with a focus towards a positive and more harmonious future. It must be noted that, whilst the mediation sessions are confidential, a member of senior management does need to officially sign off on the final agreement. The option of making a formal complaint is very clearly explained in the policy. The formal complaint would be made in writing to the Director of Human Resources. This should include details of what happened and what informal steps have been taken to solve the issue. If no informal steps have been taken, then the reason why must be included. The Director of Human Resources will then investigate the matter, and the complainant will be made aware of these allegations. Once the investigation concludes, the Vice-Chancellor of the University decides upon what action and restitution should occur, if any. The final option available to you is to lodge a complaint under the Work Health and Safety Act of 2011 or with the Fair Work Commission. The Work Health and Safety Act in Queensland states the main objective of this Act is to secure the health and safety of workers and workplaces by A. Protecting workers and other persons against harm to their health, safety and welfare through the elimination or minimisation of risks arising from work, and C. Encourage employer organisations to take a constructive role in promoting improvements in work health and safety practices. The legislation exists to protect the physical and mental health and safety of employees and other persons at a workplace by providing safe plant, premises, working environments, equipment and appropriate trained workers. It is possible that you could argue that the university has not protected your mental health and that they have not provided adequate trained workers in the form of Brian's reluctance to address your complaints. If you wish to lodge a complaint under the Workplace Health and Safety Act, you need to contact WorkCover Queensland. The Fair Work Commission is an independent national workplace relations tribunal. One of the main types of disputes that are referred to the Commission are disputes that arise under the General Protections provision of the Fair Work Act of 2009. Their role is to resolve workplace-related disputes by providing services such as conciliation, mediation and arbitration. If the Commission is unable to resolve the issue through the methods listed above, then a formal hearing could be necessary. To lodge a complaint under the Fair Work Act, you would need to contact the Fair Work Ombudsman. Now that we've had a look at all of the options that are available to you, I wanted to explain further some of the risks and benefits that can come with these options. Firstly is the option of speaking directly to Brian and Alex and raising your concerns with them. This will allow you to decide if there is a real problem or if it is in fact just a clash of personality styles. It also has the advantage that you will be able to help develop your professional relationships and show that you hold some power in this situation. The difficulty with this step is that Alex and Brian may not be willing to have the discussion, or they could actually exert their power over you, manipulating the conversation and the outcome. Now let's look at the option of mediation. Some advantages of mediation is that it is a structured process that allows for control and resolution with both parties. It costs less than if the matter went to court, and it's not limited by time constraints. It can also lead to a quick result, and what is discussed within the mediation sessions is confidential. A potential risk with mediation is that there is no binding authority, and that both parties are free to reject or accept the mediator's recommendations. In addition, whilst the sessions are confidential, it means that evidence from other parties or witnesses could not be considered, so a potential he said or she said situation could occur. Mediators also do not have the power to enforce reparations or consequences should the bullying behaviour continue. The formal complaint process detailed by the university is in place to give workers the support that they need should injustice in the workplace occur. The university has a responsibility and obligation under both state and federal law. However, you do need to be aware that by raising the breach of the workplace bullying and intimidation policy, there could be an impact on the contract of employment that both Alex and Brian have with the university. Additionally, you also need to be aware that you will still be working at the workplace while this formal complaint process is taking place. There are also some things to consider if you decide to use an external system to address the conflict. Whilst the Fair Work Commission can make orders to prevent you from being bullied further, it cannot order monetary compensation as a result of the bullying. In addition, you must be able to prove that the bullying that has happened has been repeated, unreasonable, and has created a risk to your health and safety. As you think about all of the information that I've given you today, Chris, I would like you to consider the following. I would strongly advise you to stay off social media and to respect the privacy statements within the policy. Discussing the issues that you have on a public forum could put you in breach of the university's policy and procedures. I would also advise you to carefully consider the options that are available to you and the potential social and work ramifications that could occur should you wish to act. It could well be that there may be some form of social retribution. You could be labelled as a troublemaker. Whilst I cannot make this decision for you, what I can tell you is that Alex and Brian appear to have breached the university's workplace bullying and intimidation policy, and you do have the right to act on this. You also have many options available to you. So please feel free to contact me if you have any further questions or if I can assist in helping you enact any of the actions that I have previously mentioned.